Great news! Green card approved in 64 days, friends. 64 days. National Interest Waiver, EB2 category, employment based. Can I self-petition? The answer is yes. You can self-petition provided that you meet the eligibility requirements. What are those eligibility requirements? In this video, I'll talk about those eligibility requirements. I'll give you a timeline and I will provide additional advice on adjustment of status when you are not within lawful status. My name is Bijoux, Ngwanda, I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex U.S. immigration law cases. If you're new to my channel, again, please go ahead and subscribe. But if you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Also, do not forget to join me really on my private Facebook group where we answer questions live at least twice a month. We try our best, okay? Then you can also follow me on Instagram. Please, you do have to follow me on Instagram because we are really talking about those type of petitions, employment based, giving advice, tips, really going deep into the employment base and trying to find a way for you to adjust status, finding all the exceptions so that you can adjust status, provided that you again meet those eligibility requirements. Let's get right into it. This is a great news, friend, because this news came about actually the day before Thanksgiving on November 23rd, but I did not know about it because, you know, I don't go ahead and check every single day. But my client went ahead and checked. She tried calling me yesterday on Thanksgiving, but unfortunately my phone was off because, you know, Thanksgiving, trying to celebrate. But again, today when I turn on my phone, then she reached out and said, yes, I got my approval and my card is being produced. And guess what? We filed for this green card on September 19. That's when they actually received the application. And on November 23rd, 64 days later, the green card is being produced without an interview. Why? Because we file with everything, a medical examination, meeting these or those requirements, and any other documents, including the additional fees because my client was adjusting under 245I. What is the priority date for this petition? This priority date for this petition was September 7, 2021, because remember, we filed first the I-140 petition, which took a little longer than expected, at least around 11 months to get approved. Then later on, we actually moved and filed for the green card because we wanted to know first whether or not I-140 can approve, especially when we have those cases where it's like 50%, where we really have to make a strong argument. We do not strategically file everything at once because we do not want our client to lose a lot of money in attorney fees and USCIS fees. That's why we had to split it up. But if your case is really straightforward and I look and I see that it's 70%, there are 70% chances of you succeeding, then we will file everything at once, okay? So it's just strategically how we proceed. That's the timeline I gave you. So in other words, it took only 1 year, right? And 2 months for her to get her green card. If we look at the totality of circumstances, 1 year and 2 months. But the actual green card, for it to get processed, was processed within 64 days. That's how great this news is, without interview, without further requests for additional evidence. There were none of it because we were so strategic in our filing. That's what we do when we file. Sometimes we get requests of evidence because, you know, our strategy was different depending on what type of cases we're dealing with. But this one, it was really good. So let's talk about interest waiver, right? What is it that makes really USCIS get your case approved? Give me 1 second. I'm gonna just go here on my computer, trying to get it right. Just give me 1 second. Yes, so what is the actual element that USCIS look at when they're looking at national interest waiver? Okay, first, the applicant proposed endeavor must be of substantial merit and national importance. Okay, substantial merit involve a variety of fields. We have business, entrepreneurship, science, technology, culture, health, and education. National importance in the context of entrepreneur, which was the case for our client, the entrepreneur project can meet this condition if it has a significant potential to employ U.S. workers or has had a substantial positive economic effect. You see how they say substantial, significant potential, okay, to employ. USCIS really is looking at the potential of the business, right? The potential of the business, not the actual business the way it is now, but the potential of the business. If you can prove it, you got that element. Okay, then we move to the second element. The applicant must be well positioned to advance the proposed endeavor. That's when we go with degrees and stuff like that. So to determine whether the applicant is well positioned, USCIS mostly, not all the time, but mostly focuses on prior results as indication of the future probability of success. They look at what you've done in the past. That's when we go into your work experience, okay? Even if the work experience wasn't in the context of your entrepreneurship, we go back and look at where you were working, the success that you had. That's when we went with supervisors, letters of recognition. Whatever you were able to accomplish in the past can show the potential for probability of success in the future, okay? And then lastly, on the balance, it will be beneficial to the U.S. to waive the job offer and labor certification requirement for the EB2 category. And then to determine that, it's basically the USCIS look at whether in light of the nature of applicant qualification, endeavor will be impracticable to secure a job, or whether USCIS will still benefit from the foreign national contribution, whether the national interest of the foreign national contribution is sufficient urgent to warrant foregoing the labor certification. In this case, really, it's about this entrepreneur who is my client. Basically, the way we actually argue was that given the age, most likely the U.S. employer will pass on her because she's almost reaching the age of retirement. So it's almost like impractical to just get a job offer from an employer to actually sponsor you. You know, in general, they will want to sponsor a younger individual. So it was pretty much impractical. So that's why she had to go with her own business, entrepreneurship, and we were able to deliver. We argued, and it was really on point. And we get an approved petition, I-140, and now we got the green card petition approved as well. But guess what? My client had to adjust on the 245I because of unlawful presence. Remember, 245I covers unlawful presence, entry without inspection, work without authorization. Those three concepts get covered under 245I, which we've talked about in the past. You can just refer back to my previous video to understand 245I. What I wanted to add again on this petition, or in general for adjustment of status, if you don't meet the requirements of maintaining lawful status, we have an exception, right, under 245C2, which says that if there is technical reason, right, basically not fault of yours, you couldn't maintain status, then you can argue that, which we have a case in the 9th Circuit, which this lady really argued that on the employment base, because her asylum was pending, she was able to adjust status. Remember, asylum is not a status. It's just pending while they decide your case. But because she filed for asylum 6 days prior to the expiration of her B1/B2 visa, which B1/2B visa is valid for 6 months, right? But she moved with the asylum application 6 days prior to that expiration. Then she went on and argued on that technicality exception, and she won. So if you want to use that case for the 9th Circuit, it has to be, if you're not in the 9th Circuit, right, it's kind of like a persuasive way to persuade a judge, but the facts must be either distinguishable or similar. If they are similar, yes, you can use that case to persuade anybody in any other circuit. Remember that if they're not in the 9th Circuit, they're not mandated to follow this case law of so, but they can be persuaded to follow it. So we will talk a lot again about exceptions for people who do not properly maintain lawful status, how they can adjust status. If 245I doesn't fit your criteria, what about 245C2? Okay, we look at all the exceptions. If we find one, we apply it in order for you to adjust status, even though you did not maintain lawful status. You want to find more? Please call 202-751-2180. Email bijoux.ngwanda@gmail.com. You can also schedule your own consultation using the link in the description box below. Until next time, bye-bye.